Well, this morning the Constitutional Court will hand down judgment in the matter of Isak Baron and others versus Claytile. Now, this matter relates to Claytile removing its former employees from units they had lived in while in their employ. The responsible municipality indicated that it was not in a position to provide alternative accommodation. The Magistrate's Court held that the respondent complied with the requirements for an order of eviction as set out in the extension of security of tenure ESTA or PI, and found that the applicant's employment had been terminated lawfully. Therefore, their right of residence was terminated and an eviction order was granted. Jackie Dugard is a constitutional law professor at Wits University, and she joins us via Skype. Prof, thanks so much for being with us here on the program.
Thank you very much.
Let's take a look at this particular case and in the backdrop begin by speaking about the rights of evicted ex-employees versus those of Claytile in the matter. What are their rights?
Well, the rights are set out in a series of acts. One of them is called ESTA, as you said, which is the Extension of Security of Tenure Act. And the other one is the Prevention of Illegal Eviction from an Unlawful Occupation of Land Act, which is otherwise known as PI. And I'm not sure precisely which act applies or both in this situation, because ESTA applies to, roughly speaking, rural land where there has been consent to occupy, whereas PI applies across the country anywhere and includes unlawful occupation.
Yeah.
But in this case, assuming it's ESTA, what happens under ESTA is that if a residence arises solely from employment, then if the employment is lawfully terminated, then so is the right to reside.
Okay.
But it has to go through court.
Yeah.
So this is what is being waged in this case, is to see whether the residence arose solely from employment and whether that employment had been lawfully terminated.
Okay, so that's what this is all about. But if we look at the responsibility of the municipality, what are their obligations towards homeless people? Because in this particular case, they said that they don't have, that they've got absolutely in no position to provide alternative accommodation.
Well, the responsibility, according to Section 26 of the Constitution, is that the state must provide emergency shelter to people who would otherwise be without a home. So they do have that obligation. And it has been clarified in a series of cases, including one called Blue Moonlight, where the Constitutional Court said that indeed municipalities have an obligation in respect of people evicted by private landlords.
Yeah.
So the only question is if the municipality genuinely is unable to budget for this. Now, so far we haven't had any case where the courts have agreed that a municipality is absolutely unable to find the resources. It is technically possible that a completely bankrupt municipality might be able to say we don't have the resources. But that would be very hard for a municipality to prove, because one, they have an obligation to budget for these things. Two, they also have an obligation to secure the funding from province or from national if they don't have the funds themselves.
It's quite interesting because I can imagine the ruling of today, whatever the Constitutional Court says, is going to have a wide-ranging impact on a lot of other issues. I mean, I'll just take, for instance, what's happened in Joburg. We saw the fires in a building. A lot of people have been displaced there as well, and they were being evicted. Is this sort of something that we're going to see having a repercussion on a wide range of these stories that are all over the country?
Yes, of course, this has been happening for a while. It has been established for some time now, since the Grootboom case in 2000, that the state, whether it's the city, the province, or national, has the obligation to provide emergency shelter where people are evicted and would be left homeless. So any eviction, whether it's by the state or by a private landowner, that will result in homelessness, then the state has the obligation to provide emergency shelter.
Yeah. Just a final closing note. A magistrate's court has already determined that the proper process was followed. The Constitutional Court, I mean, what do you think the outcome could possibly be?
I think that it's highly likely that this decision will be upheld.
All right. Well, we wait and see. It'll be handed down today, so it's quite a big and very important issue for a lot of people when it comes to evictions and whether it be unemployment or evictions and losing your accommodation. What is the responsibility of the municipality? So let us know what your thoughts on the extension of security of tenure and the fairness of evicting the applicants from private land. Is it just? Is it equitable? We'd love to hear from you at Morning Live, SABC. Join the conversation. All right. That was talking to us Jackie Dugard. She's a constitutional law professor at Wits University. Let's take a break. We'll see you after this.